Mr. Martin Daly, good morning to you, sir.
Good morning, Rennie.
That voice is that of the former Law Association President, Columnist, and Senior Counsel, Martin Daly. Our discussion this morning centers on Wednesday's upheaval in court, a presidential appointment to an institution that should reflect the highest levels of accountability and stability. It is a scenario where you look at it and you go like, is this a play? No, it's improbable. No, it is not true. But you know what they say, truth is indeed stranger than fiction. So, Mr. Daly, I'm gonna recap this situation. You will tell me if I'm exaggerating this or if I'm reading it from another play. If I understand it well, it goes this way. A chief magistrate, Marcia Ayers-Caesar, appointed to the elevated position of High Court judge. After less than a month, the High Court judge resigns and very soon will be reappointed chief magistrate. Question is why? Well, the distinguished chief magistrate High Court judge did not fully disclose her large caseload and the impact it would have on the citizens accused of various crimes. Since then, there are many other folks who are calling for her head. Some are calling for the head of the chief judge in the country. The question is, who done it, or rather, who is to blame? Did I capsulize that correctly, sir?
Yes, you most certainly did. So, and there's good morning to your listeners.
Good morning to you, sir.
There is the primary responsibility for this monumentally troubling issue lies with the Judicial and Legal Service Commission.
Mm-hmm.
If you are making any appointments, particularly one of this caliber, the appointing body must exercise its own due diligence. It's a bit like if I always break things down in a simple way. It's like if you are going to employ somebody in a high-powered job and you ask them for references, due diligence requires that you follow up the references. If they say they have a PhD, due diligence requires that you follow up that they have a PhD. So there's no way I am being deflected from saying that the primary responsibility lies with the Judicial and Legal Service Commission. They failed miserably to carry out their due diligence.
Because
that's the first thing. That's the primary responsibility in this matter.
Indeed.
Then the next problem we have is that assuming, now bear in mind we don't have all the facts, they're very skillfully keeping everything very opaque. We were first told, well, the former chief magistrate had a number of paper committals, implying that getting those reorganized if she was elevated to the bench would not be a problem.
That statement came from the Court Protocol and Information Manager, Alicia Carter Fisher.
The buck can't stop with her.
Okay.
Then we started to hear that the magistrate had a number of part-heards. Now, part-heards, let me just explain. Part-heards are matters, as the name implies, are partly heard by a judicial officer. So, Mr. Justice Smith is hearing your matter. He's not finished it, whether he hasn't heard all the witnesses, whether he hasn't heard all the submissions, whether he hasn't delivered his decision. That matter is part-heard until decision is delivered. That is quite different from a matter that has never started. And the particular mischief of interrupting part-heard cases is, of course, some other judge then has to hear the witnesses or the submissions all over again, and that is extremely disruptive and expensive. Now, it turns out, apparently, that the former chief magistrate had some part-heard cases. We don't know how many, and they haven't told us. They haven't told us. She disclosed items 1 to 7. But the facts were there were items 1 to 107. They simply haven't told us that. So we don't know the extent of the non-disclosure. Then they say, well, we can't dislocate all these litigants who have part-heard matters, so we're going to put her back. But we have to pause there. Yes, it's a disaster if people have all those matters we don't know how many, but all those matters have to be started over with the attendant disruption and expense and so on. But the question then arises, how can you reappoint someone to judicial office who, at his lowest, misled you, if not was downright untruthful? There's a much bigger question than the dislocation of all the litigants. There's a much bigger question of, can we as a country knowingly have put someone on the judicial bench who has admitted to misleading the commission? So that it's no point trying to say, oh, well, it's all fixed, we put in her back. It can't work like that. You know, let's be very practical. presumably if she's going to be reappointed as a magistrate, it's not clear that they're reappointing her as chief magistrate. Is the president going to swear in? Yes, it will be said that if he's advised by the JLSC to do it, he has no choice under the Constitution. But do we want to embarrass the President of the Republic by asking him to administer an oath to somebody who has been knowingly untruthful? I mean, it boggles the mind.
Well, it still stands up exactly what you said. Senior Counsel Martin Daly is the voice you're hearing on the other side. The question is that we don't have all the facts out because, as you said, if it could be a case of 1 to 7 disclosed or even 1 to 100 disclosed, but the details of all of that not being disclosed. It's still, I want to stay in the area of the Judicial and Legal Service Commission.
Well, so you should, because they are to blame.
Because this is crazy. What is given to the Chief Justice is a result of their investigation or their due diligence, as you say. And we have a situation where they cannot be the ones then, even before we get back to the reappointment as Chief Magistrates, they cannot be the one to step in and say, we have approved that she be reappointed.
No, they can't do that. I mean, just think about the inconsistency of swearing an oath on whatever book or instrument to say you're going to be true and faithful to justice. Those are not the exact words. When the person taking the oath has not been true and faithful to justice by their own conduct, it boggles the mind. I am not underestimating the difficulty that will be faced by litigants or accused persons who have to have their matters done over. But there is a much bigger issue here. The country has now been given the impression that the judiciary is a bunch of bunglers, and why should they be allowed to make life and death decisions over us?
Everywhere we have heard of the Chief Magistrate, we have heard of her reputation and her dedication. It has been beyond reproach from all that I have read. She has apologized for the impact of her decision, saying what it had on shareholders and the criminal justice system is regrettable. She also expressed regret at the effect which her action may have caused every person whom she has strived to serve. The Chief Justice, however, was rather scathing in his remarks. He said he had failed to, she had failed to manage the transition from the magistracy to the High Court in a way which ensured that undue hardship was not placed on stakeholders, and she had departed from established practice whereby successful candidates ensured they have fulfilled all outstanding professional obligations before advising the Commission on their availability for the appointment. Did the public scolding by the Chief Justice undermine the integrity and the standing and the perception of the Chief Justice?
Chief Magistrate.
The Chief Magistrate, I'm sorry.
Yes, absolutely. Why did he have to give her a public schooling? If she said, I've done something wrong and I've apologized, leave it at that. But of course, they're hustling to say it's all her fault and that no blame attaches to them. And it's interesting that even those who are saying, oh, well, you know, give them an ease up, are still accepting that they had a responsibility for due diligence in the matter. They had no business now to turn around and publicly scold the Chief Magistrate, who, whatever she may have done, had hurt her career. They had no business to turn around now and vilify her, accept her apology, and if you were going to make what I consider a wrong decision, make it. But don't accompany it by this vilification. She's a human being, and if she's made an error, she has to be justly treated as well. She can't just be excoriated or put in sackcloth and ashes because she made a mistake when they should have done the proper due diligence in the first place. So from a point of view of meting out justice and fairness, the scolding was not required. If they were going to put her back, what was required? To accept her apology, say it was a regrettable situation, and if it was their decision to put her back, put her back. I don't agree with the decision to put her back. But they have treated her extremely bad.
It is one of the reasons why, DePracy, to my question to you, dealt with the fact that she is someone who is beyond reproach. We've only heard good things about her character and the carrying out of her duties, and it's amazing that suddenly everybody's in a position where they're calling. Are you disappointed or surprised by that the president of the Criminal Bar Association, Pamela Elder, and senior counsel Israel Khan are both saying that Ayers-Caesar cannot resume hearing matters that were left their part heard, as you said? Former Chief Justice, however, Michael de Labastide says he sees no reason why she cannot.
Well, I think that there is a legal question about whether she can come back and finish matters. But this goes much beyond. This is about what is legitimate, what is proper, what is calculated to keep the administration of justice in high regard. And you cannot put somebody who is guilty of a non-disclosure and has admitted it to try other people and to decide where truth and falsehood lies. You're putting her in an impossible position. She ought not to be put in that position, whether it's legal or not, which I doubt, is a separate issue. And then you scold her on top of that, in other words, to make her look as bad as possible in order to make you look better. I totally reject that. I mean, as a piece of human resource management, it stinks.
Do you agree with what the Chief Justice is advancing? However, he says the JLSE and himself were not made aware of the full extent of our obligation before the lower court.
Well, if they were not made aware, the question remains. I gave the example of following up references, for example. Take another ordinary. I'm trying to show the due diligence that the appointer has to do. Take another example. You interview somebody, and you think they're going to make the shortlist, and the last question you ask them is, if you are successful and we decide to offer you this employment, how much notice will you have to give your current employer? Those are normal incidences of due diligence. And precisely in the same way, they should have asked the candidate, what is the state of your list? Do you have part-heard matters? How many? When do you think you can complete them? And they have not told us if they asked that question. What is implicit in what they're saying is somehow they expected her to volunteer that without even the most basic question being asked.
Which means that the JLS, the Judicial and Legal Service Commission, then would just be sitting down there taking whatever I hand to them.
Yes, that can't be right, especially at that level.
Is there a possibility that the good Chief Magistrate, judge, former judge, underestimated the ability to dispense with what she had part heard? Is it possible she misunderstood the full impact of not...
Well, we don't have the facts, but that is unlikely.
Very unlikely.
If you have, even if it's two part heard matters, it's going to take you some time to bring them to a conclusion, because you have to fix dates that are amenable to the lawyers and the litigants in the question. It takes a while. And when you decide you're making an appointment like that, if the person is already serving in some judicial capacity, the state of their list is the most fundamental thing of all. And the JLSC have not even told us whether they popped the question. They're simply saying she didn't volunteer anything, but did they pop the question at all? Or were they sleeping on themselves?
You are calling for the Judicial and Legal Services Commission to demit office, while others are also saying the Chief Justice should be impeached. Is this a case of a hammer being prescribed to correct the angle of a hairpin, or is there validity in the calls?
Well, I think we have to understand that when we are saying that the commission, the members of the commission have put themselves in an untenable position, they have put themselves in an untenable position as commissioners. He happens to hold two offices, Chief Justice and head of the commission. And of course, if he has to resign as the head of the commission, he'll have to resign as Chief Justice. But you know, Rennie, Trinidad is an interesting place. If you look at the newspapers today, there's more trouble for this JLSC on the horizon.
Yes, I see it indeed with Judge Williams, yes.
So there's a whole, this is the whole expression about you can run, but you can't hide. This is by no means over. All of those who are rushing very quickly to paper over this as a crack, better be very careful to see what else is going to emerge in the coming days about these appointments.
Which raises brings to mind a point I wanted to ask you. Prima facie, is there a good enough case that's being made on the errors of what has happened here, or is there also a possibility, as some have opined, that there are folks with agendas here who are making this way more difficult than it really is?
Absolutely not, and that's another problem we have in Trinidad. I'm not going to call any names, but let us assume that someone who may not be politically popular in one section or other of the community buses a mark, as we say. Any detached, intelligent person, particularly one who is exercising enormous powers on behalf of the state, has to sort out the message from the messenger. And just because you don't like Daly, if he tell you, look, that high tension wire is about to burst and electrocute and kill you, What are you going to do? You're not going to look at the wire and see if you're in danger and forget who's telling you that. I'm sorry to give these very homely examples.
But it makes sense. Mm-hmm.
And we can't just dismiss something that somebody says because you don't like them, or you don't like their politics, or you don't like the side to which they belong, or you don't like the orientation.
So you don't see a political agenda playing anything in all of this, or ethnic?
Well, it may be playing here, but the point about it is these mistakes create fertile ground for political agendas. And if somebody's a politician, why shouldn't they play their political agenda? The point about it is there some issue here that transcends somebody's narrow political agenda?
Okay.
That's what is at stake here. And we're just not able ever to sort out the issues from the personalities.
The political or ethnic agenda is irrelevant, you're saying, because there are sufficient errors going on here that this alone deserve scrutiny and correction.
Yes, there is a transcending issue. Did the JLSC do proper due diligence on any of these candidates? And if what is now being foreshadowed in the newspapers today is any guide, it's going to turn out that there's some other due diligence that may have been overlooked. And then it brings into question, well, why were they so soft on these people?
And this involves the wife of the acting police commissioner.
Well, I'm not so interested in that. It involves the candidate.
Indeed. I was only giving...
what may have happened about the candidate, you know?
Merely giving a backdrop to our listeners, sir. I agree with you.
Somebody could have a... That's another thing about shooting the messenger. Somebody might have a spouse or an association we don't like, but that doesn't mean that, you know, the person doesn't have merit on their own strength. I completely reject all of these emotional kind of partisan judgments. I try to look at an issue as best I can.
I concur 100% with you, sir. Merely giving context here. Senior counsel.
I understand. And I just, you know, when you call me Rennie, it's usually about something I feel passionate about.
Indeed.
And I cannot believe that these people cannot see the damage they're doing to the judiciary as an institution.
What corrective measures can be put in place? What sort of resolution you see coming of this situation? As you said, more to come, but let's just deal right now with the Chief Magistrate, the former Chief Magistrate, former High Court Judge, to be reappointed Chief Magistrate. What is the best scenario you see playing out for this?
That, in my view, in the wrong way. But if this is not to happen again, then the commissioners must take full responsibility for their lack of due diligence, and then they will have to decide, having taken full responsibility for their lack of due diligence, what is the appropriate consequences for them. I'm very clear in my mind what are the appropriate consequences in this case, and I've said so. They are in an untenable position.
So the resolution, as seen by senior counsel right now, that could be satisfactory is one, the removal of the joint Judicial and Legal Service Commission.
They must remove themselves.
They must remove themselves.
Position. They must remove themselves.
And also
accept that they have brought the judiciary into disrepute, and that they have compounded it by making a bad decision to reappoint someone who was untruthful to them, and stop trying to put everything on the shoulders of this poor person who has made a mistake and has already paid sufficiently for it.
And the Chief Justice, the call for his impeachment?
Well, I don't know when we get to the stage of impeachment. You see, I'm very different. You know, I think people have to examine what they've done, self-analyze, and decide what the consequences should be. Long before we get impeachment, because then you're involving the president, the office of the president of the republic, and all this kind of thing. It's exactly the same. If they're commending, everyone is commending the former chief magistrate for removing herself from the, you know, coming out of the trouble and so on. Then why does that not apply to the other people who created the trouble? If it's so commendable for her to resign her appointment as a High Court judge, what would have happened if she said, you know, the old whole CX calypso? What happened if she says, I'm moving? Then we would have had the messy business of trying to impeach her, and then her defense would have been, you're impeaching me, but you didn't do your job. When something like this happens, you have to have a clean break. And my view of this is also affected by the fact that this JLSC have done some other things that have caused disquiet in very recent times. And I gave the example of praising someone as a future judge when you're the head of the commission that appoints judges. I don't know what is going on.
Martin Daly, Senior Counsel, just to complete an observation reportedly attributed to you, sir. You said it's unthinkable, and I think it goes in concert with what you said here this morning. It is unthinkable that the JLSC should be blissfully unaware of the impropriety of appointing or restoring someone to the judicial office of magistrate after that person has admitted provided incomplete information to the JLSE in pursuit of appointment to a high court bench. Martin Daly, I think we have made the point as it relates to this. I do want to ask you a couple of other areas here, and this has nothing to do with the merits or demerits of property tax. That's one thing that is not being discussed here. There are, however, political representatives who are directly or indirectly advising people not to pay their property taxes. My question to you is simply of a case of legal standing. Can they be charged or be held as complicit in encouraging people to disobey the law?
Well, I doubt it's as simple as that. The Valuation of Land Act prescribes certain things, including the power to enter premises. But ultimately, if property is lawfully imposed on you and you don't pay it, ultimately it will attach as a debt to your property and you'll pay a very high price. But we are a long way away from that. The first issue is whether we should comply with the requirement to send in all of this information that is not provided for in the Act. I notice the government is soft pedaling now, and spokesmen are saying, gosh, well, just give us the deed and your land and building taxes receipt. And maybe just say what kind of home it is, and we will accept that, and then you won't get a visit. But again, there's a much bigger issue. People coming in a peaceful country, we in Finland or Sweden, where they have must be one murder a year and 2 suicides.
It's different.
That's a very different environment in which you're talking about 166 odd murders for the year and asking you to admit strangers into your home. And the stranger might be very nice, but we don't know who they're liming with. We don't know what the pillow talk will be when they go home about whose house they went into and what they saw there.
That's the subject
very practical about these things.
That is the subject of your article today in the Trinidad Express, and that's Martin Daly's column. You're dealing with the whole question of how safe it is to have these valuators who, under law, are empowered to go into your house and do the validation. And that is an angle that I hitherto have not heard discussed, but I understand clearly that it is the disquiet that follows a lot of people right now about complying with what is a prereq.
I don't know anybody in Trinidad who is readily accepting, and I know many people who will protest virulently if a stranger has to come in their house and walk through the house. I gave you the example, it's like a Sparrow Calypso. There's a man in my bedroom, man or woman, you don't want a man or woman in your bedroom, any other part of your house. If I tell you I have a 3-bedroom house in X area, why can't you simply look at my property from the curbside and make a valuation? Or better still, why can't you say that this area is an A-class area, B-class area, C-class area, as the case may be, and impose a tax on the area subject to individual people appealing and saying, well, even though I am living in this Class A area, my house is an unrenovated shack from 1936, have an individual appeal. The country is not going to accept strangers coming into the house with 166 plus murders, only about 10% of which get detected.
Speak to me to the best of your knowledge, Senior Counsel Martin Daly. Is there anywhere else in the world where folks actually come in and do an appraisal from the inside of the house because of this property tax?
But there are not many countries that have 166 murders at the conclusion of the first quarter. So whatever, as I say, you tell me about Finland, Sweden, or anywhere else, I know what the crime situation is here. And I know what people's associations are, and it's not just about the stranger, but with whom are they associated? What indiscretion will escape their lips? Boy, I went to that man's house, and if you see the size of his television, and you have 3 of them. We have to live in the real world of Trinidad. This is not a place where we are closed-mouthed and very confidential. And we have to, and in that real world, there's a strong case to be made for not forcing people to accept strangers in their homes. That's the first thing. Likewise, submitting a photograph of the property and all that. A 3-bedroom house is a 3-bedroom house. Whether it's painted red, white, and black, or shell pink, or has pretty fretwork is neither here nor there. It's a 3-bedroom house in X area.
Understand.
You see where the people's gates are, where the entrances and exits are. Why must I put all of that in the public domain?
Two very provocative articles, and I urge folks to go and read your column today. Two concluding questions, Senior Counsel. One has to do with the Prime Minister's statement that sounds sensible to me, because it did strike me early. There are a lot of folks who are talking about those who are squatting here or there. The Prime Minister said there is a good argument to be made that squatters cannot be taxed, for if you did so, you would be legitimizing an illegal occupation of the said land you said they are squatting on. Do you agree on this? And if you do, is there any way the nation would be able to extract any revenue from those who are sitting on such lands?
Well, interestingly enough, lots of people call me and about different things. About an hour ago, someone was telling me on the phone that the easiest way to introduce property tax is to put a percentage on the light bill, because whether you're a squatter or you live in a penthouse, you have a light bill. That light bill is going to reflect whether you have 4 air conditioners running all day. You have long time jealousy with a fan. And everybody will pay a tax based on electricity consumption as a start, and TNTEC have all of this already computerized. So it's a great way to start and settle down everybody to this charge and then move on from there. People are very creative and inventive in this country.
But you may be interfering with some plans later on, because I'm pretty sure that TNTEC is going to have their own increase.
Well, that's maybe. Well, then we'll have to get 2. 2
increases, okay. We'll
have to get 2. One for the deficit in TNTEC's accounts, a reported deficit in their accounts, and one as a means of collecting the property tax. The same way you collect a fuel tax ostensibly to defray the increased cost of energy, which happens in many Caribbean countries. Collect a fuel tax. Same way you collect a green fund levy, supposedly to go to the environment. We don't know if it does. Same way you collect, there's another one which I forget, the health surcharge, supposedly for the health sector, but it doesn't go there. It's perfectly possible to collect things and segment them or dedicate them to particular purposes. And it's a very, electricity is a very even-handed thing.
That actually makes a whole lot of sense.
Well, it's not my idea. Somebody suggested it to me and mentioned some other country in which it's done, but I've quite forgotten which is the other country.
Smart people hang out with smart people. Good.
No. Well, the average Trinidadian is very smart.
Indeed.
Some is smart in more ways than one, but never mind.
Where there is a will, they will find a way. Senior Counsel Martin Daly, thank you so much.
That's you unusual, and I can't help being passionate about the things you call me about.
It is the passion we want.
And a good morning to your listeners. Thank you for having me.
Thank you, sir. Have a good day. Martin Daly, Senior Counsel.